Well, I would like to start, first of all, saying that I feel really honored and humbled of the experience of been with you here in India, in Bangalore. And I want to thank you, the Center for Law and Policy Research, the Center on Law and Social Policy, and Astria for giving me the opportunity of sharing what is going on in Peru and other Latin American countries. So we can share experiences, and maybe you could learn a little bit of what is going on with us. And also, I could enrich my view with what's going on with the struggle here in India. My name is Carlos Zelada. You can call me Carlos. And I'm a law professor. And what I'm going to show you now, it's 2 or 3 years of research, and it's a research that is still going on. Has been recently published, one part of the research, only in Spanish, but hopefully we can get the chance to translate it into English too, so it can be even more useful for what's going on here. And we call it Translegalities, and it's a preliminary study on the judicial files on recognition of trans identities in Peru from 2003 to 2016. There's my email if you want to the presentation or any other material that could be useful for you. So I would like to start talking a little bit of the Peruvian scenario. Peru is in South America, and it's a country and it's a region that has advanced a lot on LGTB rights. However, Peru, compared to its neighbors, it's way behind. There's a lot of a struggle, not only at the Congress. No real laws had been passed in order to advance LGTB rights. So we are trying to do this through the judiciary. And it's a constant struggle. When I listen to you, what I'm listening right now in the morning tells me that we share a lot of the same struggles. So when we started this research, we were wondering if legal Peruvian academia had been interested or not in trans studies. So one of the first questions we posed was if there a Peruvian trans legal studies movement. And we had to accept that there's not. The approach of most professors and attorneys has been very opportunistic, but never systematic. Was kind of academia was only reacting to certain final decisions, but we never went into studying the files or trying to see if there was a trend to be looked at. So having said that, in my country, there's no gender identity law, okay? So if you're a trans individual, you need to go to the judiciary in order to get legal recognition of your social name or your gender marks. Last year, in 2017, a gender identity bill was presented, and it's still there at the Congress. There's no further discussion of it. And it's part also of the view that many of our congressmen has about this issue. It's like not important. But myself and many other colleagues, we believe it's substantially important to advance equality and the principle of non-discrimination in our societies. So hopefully, eventually that bill will be discussed and be transformed into a law in the future. And one good thing about that gender identity bill, that's the name in Spanish, Proyecto de Ley 790/2016/CR, is that it was prepared and made and thought by the trans movement in my country. So it's something very important, because if it's eventually transformed into a law, it would be something that started with the trans movement, not from the professors or from the ones that do not belong to the movement, but the movement itself. So, having said that, recently, the Peruvian Constitutional Court had 2 decisions. One is the PEM decision in 2014, and the other one is the Romero Saldarriaga decision in 2016. The PEM decision was an ugly, bad, awful decision. PEM are the initials of a trans woman that already had her social name recognized by the courts. So she was going to the Constitutional Tribunal requesting the recognition of her gender identity. The court said, the sex and the gender that you are assigned at birth cannot be changed. So after that came the Romero Saldarriaga case, which is the last decision in the Peruvian jurisprudence. And the Romero Saldarriaga case said 4 things. First, it changed the PEM decision saying that gender provides a social and flexible legal framework. It recognized that gender/sex can be changed. So it really turned over what has been said in the previous case. Then it says that transgender identities are not pathologies. Then, as a result of that, the court said that there is a right to request the legal recognition of gender identity. However, the Romero Saldarriaga court said, you still have to go through the judiciary to get all those recognitions on your identity documents. That's the scenario where we are. My research has been focused on all the moments, all the cases that has been before the Romero Saldarriaga case. Because I do believe that even though the jurisprudence is starting to change, the judges and the petitioners and the movement still think with the previous framework that have the PIM case as a result. So what happened? We get access to 13 cases, and these 13 cases were really difficult to find because even though you are a researcher, if you go to the archives of the Peruvian judiciary system, you have to pull out a miracle if you want to get the file itself. We were very lucky, and we get the chance to study 13 files, okay? And these 13 files, and I want to explain what is going on there, belong to 11 petitioners. There are some asterisks in some of the numbers. For example, cases 2 and 8 belong to the same person. Cases 4 and 5 belong to the same person. So we have 13 files, but 11 petitioners. Most of our petitioners were trans women, okay? We only have 1 trans man. And our last case was the case of a cisgender man that was perceived by the court as a transgender person. And I'm gonna give details about that case that shows how back we are when we talk with judges about transgender issues, because this was a cisgender person that mistakenly got the name of a girl, and in the document was assigned a gender mark of a girl. He was just requesting that to be changed, but he was treated as a transgender person, and as a result of that, he was denied of the right to have his gender marks and his social name changed in this document. The column that says petition is what was requested. Most of our petitioners were having different combinations. Some of them only requested the change of the gender, other name and gender, and some of them only name. The N is for name, G for gender, N plus G is name and gender. Most of our cases were from Lima, which is the capital city of Peru. Only a few cases are from San Martin. San Martin is a department, a province in Peru, which is in the Amazon. It's very interesting also to see trans women and trans men in the Amazon, which is a total different experience compared to transgender people in the capital city. And I guess being India such a large country, also the experiences of trans women and men in different regions could be also perceived in a totally different way. And the other columns in that chart show how much time took to get the final decision. For example, if you see the first case, it took 6 years and 11 months to get the final decision, so almost 7 years. I'm not showing you yet what was the final result. I was just giving you examples of how long it takes to litigate cases in the Peruvian judiciary. For example, the second case was 5 years and 6 months, 2 years and 6 months. The third case, Case number 4 was just 1 month. As I said, 4 and 5 belong to the same person. So after that, the other person started another case, and her second case was 6 years and 8 months. And then you can see. So it takes a long time. So when we finished this first chart, we said, okay, we would like to see what are the final results. What happens after all these years? So if you see the final column, for example, the first person, the first case, we took almost 7 years. She abandoned the case. In other cases, the W is for win, the L is for lose, for if you lose the case. And if there's an F next to the L, it's like you lost on formal grounds. If there's an M next to the L, it's on merit grounds. But you could see, sometimes you win, sometimes you lose. There's no clear path. You start this, it can take a long time, and you don't know exactly what is going to happen. It depends on the judge, it depends on the kind of lawyer you have, and as we will see further, it depends on the kind of argument you present. Also, it's interesting to see most of the cases were presented in the civil procedure framework, okay? Only cases 9 and 12 went to constitutional procedures. In my country, if you go to a constitutional court, you present what is called an amparo. I don't know if the ones who are lawyers are more familiar with that. But in my country, the tradition is if you want to litigate the recognition of trans rights, you need to go to civil courts. It's not conceived and seen as something that comes from a constitutional framework, rather more than from civil procedure. So if you go through a civil procedure, you need you are a plaintiff, but you need a defendant. It's so interesting who were the defendants in those cases. Do you see in the column who is in first place? The prosecutor's office. That's the defendant in the cases. It's so interesting to see why a criminal institution will come in those cases. And you could start maybe to get suspicious of what kind of arguments they present when a trans individual presents a case in my country. Also, sometimes the municipality, you know, what another name for municipality? The city hall representatives come as defendants. And in other cases, for example, in case number 5, in the final part, say prosecutor's office, city hall, and RENIEC. RENIEC is the institution that provides you with the ID, okay? So sometimes the 3 of them present arguments against the cause of a trans individual that goes into those cases. So then we said, well, so it's really complicated. Not only takes a long time and you don't know what's going to happen, you have to fight against the system because the government itself, presenting through the prosecutor's office, the municipality, or the ID office, present arguments saying you are not allowed to have the legal recognition of your social name or gender marks. So we went to a third chart. And when you see surgery, you see if our petitioners went through surgery before presenting the case. And as you could see, the majority of our petitioners went through surgery before presenting the case. Even though some of them were only requesting the recognition of their social name, they thought as a strategy that it was better to go through surgery before presenting the case. Otherwise, the chances of having your name recognized in the documents would be less. If you could maybe try to see, there is a guarantee. I'm posing a question, and also if you are paying attention yet. If you see the person went through surgery, is guaranteed that he or she will win the case? Not necessarily, which also adds another element of uncertainty if you want to litigate those cases in my country. Okay, enough of the cases. So after we came with these charts, we decided to codify every single word in every single page of the 13 files. We used the En Vivo program. I don't know if you're familiar with that. I wasn't. I have very good friends that came from social sciences, from sociology and anthropology, and they told me, Carlos, what you are doing, you could see there are some trends if you use the in vivo program. The in vivo program gives you the chance to go and create codes, specific codes, for every single word. So our main objective would be to codify everything and see which codes are common in every single file, which codes are common with petitioners, which codes are common with judges, and which codes are common between petitioners and judges. Just to show if there is something going on in this dialogue that has been made through these cases. So to get the files, the 13 files, it took us like 18 months. And as a result, after we read the files, we created 37 codes, 20 for the plaintiffs, 17 for the judges. Some of the examples of the codes we created: valid consent, genitalization, binarization, pathologization, other medical procedures, right to identity, discrimination, right to self-determination, which is super important for us, right to privacy, right to health, civil procedure, no collateral damage, etc., etc. Every single code has a definition. In the article that was recently published, we published the list of the codes and the definition we gave to the codes. The codification process took us around 6 months, so total was around 2 years to do this. What were the results? In the case of the plaintiffs, 4 were the codes that were more used. For example, the first one is the code of binarization. That's the most common code among petitioners. That was present on 10 of the 13 files, and it appeared 53 times. The other code that came in second place when it happened were the right to identity, the constitutional right to identity. For me, it's kind of contradictory or ironic that next to the binarization argument, you present the constitutional right to identity argument. It appeared in 9 files, and it appeared 86 times. The other 2 codes that appeared were pathologization in 9 of the files, 63 times, and genitalization in 8 files, 52 times. We were really surprised when we saw the results when it happened to the judges. You want to see? They were the same. Binarization was on first place in 10 of the 13 files, 67 times. Right to identity in 10 files, 50 times. Pathologization in 7 files, 96 times. And genitalization in 7 files, 58 times. So with that, we started to think, and we got to some conclusions. First, that plaintiffs and judges understand each other in these cases, mainly through binary discourses. A quick way to say what is this kind of dialogue is like this. If plaintiff lives and feels accordingly with the social role assigned to the gender mark requested, the judiciary must grant the petition. That's basically the argument behind the binary code. But next to it is the constitutional right to identity, which says, okay, you have to give me what I have requested because I feel and live this way. The logical conclusion is that the judge should grant the petition. And then it says, but if you don't believe in that, I have a constitutional right to my own identity. Okay? But then we said, why, despite of that, you still have pathologization and genitalization as part of the codes? It's a total contradiction with the constitutional right to identity. So when we had in-depth interviews with some of the petitioners and some of the lawyers that work with those petitioners, we realized that this is kind of a strategy that they were using. Let's say I'm one of the lawyers of any of the trans men or women that are here. I will be absolutely honest and tell you, if you want to win, you have to present a medical certificate And if you want to get 98% sure that we're gonna get a win here, you need to go to surgery first. Otherwise, you're just wasting your time. Or it can take a long time, and I cannot assure you that you will win. So that reality marked many of these cases. So that's why in the second conclusion we say there's a constitutional right to identity that petitioners and judges acknowledge exists. But on almost every plaintiff request, it's always nuanced with pathologization and genitalization discourses, like just in case. So if you haven't gone through genital surgery, the chances for you to win are even less. I said that there is no gender identity law in my country. So how did judges and petitioners came out with the pathologization and genital surgery codes? It's simply because they realized that in the first cases, most men and women that won or presented the cases went through genital surgery first. And that created kind of a legal precedents for the upcoming cases. So that's why I said they became like informal requirements. They do not guarantee success, but it can, boost your case. And also, it's interesting to see the role of the prosecutor's office and RENIEC, the ID office, in these cases. Because in most cases, they say, I don't care you show me a medical record. I don't care that you show me, or that you show me through, a doctor that you went through through genital surgery. You are still what you were assigned when you were born. Also, the other thing that struck us down when we made this research was what kind of legal sources were used by petitioners and the judges. What kind of jurisprudence was mentioned? What kind of doctrine was mentioned? And we were surprised that there was no reference to international law. There was no reference to human rights frameworks. There was no reference to even what was going on with our neighbors. For example, you may know that Argentina has a gender identity law which is very progressive. It's considered by many that the best gender identity law in the world. How many times do you think a judge mentioned the example of Argentina in our cases? 0, nothing. Now that we have the Romero Saldarriaga case, which is the case that says there's no pathologization and that you have the right to go through the recognition of your gender identity, even though you have to go through the judiciary. What now? My question is, how will these new cases be handled by civil courts? Because one thing that the Romero Saldarriaga court said was that this is not a constitutional thing. This is a civil procedure thing. So you, judges at the civil courts, you deal with that. Me, the constitutional court, I don't want to deal with this. And you have seen, that the civil courts had handled these cases in a very uneven way. How will these new cases be handled by the same judges and by the same lawyers that were advisors to the trans men and women that presented the previous cases? Have judges changed their mindsets? I don't think so. I don't think so. The Romero Saldarriaga case was a couple years ago. So there are some cases, new cases, that has been going on. And my perception is that the judges are not using what the Constitutional Court said, and they're still using the same framework that was used in the previous decade, number one. And number two, I have realized also that even though the law is an important tool for this change, if we don't change our mindsets, if we don't become more visible, and if we don't talk with the judges and all the legal players in this field, the change could not be made. So law is only one part of, this big table that we have to prepare. But there are other legs of the table that need to be prepared in order to get a real change. There are two things I would like to mention just to finish. Am I on time? 2 minutes, okay. Something just happened. In 2015, the Inter-American Commission on Human Rights, which is in Washington, D.C., issued the first report on LGTB issues. It's a wonderful report named Violence Against LGBTI Persons. It's in English and Spanish, so you can use it. It's the first comprehensive report on the problem of violence against LGBTI individuals. And it has a special focus on trans women. The chapter on trans women is particularly important. For example, it says that in Latin America, the lifespan of a trans woman is 35 years. And another things that are really important for litigating cases. And recently, in February this year, 2018, the Inter-American Court of Human Rights issued the advisory opinion OC 2417, which is the first advisory opinion talking about equal marriage and the right of trans persons of legal recognition of their identities in the documents. It says, for example, that no pathologization should be required by courts, no genital surgery should be required by courts, and also that even though some countries like mine, for example, go through the judiciary, it's better if you go to a more simple administrative procedure. We don't know yet how this framework that is not coming from the countries themselves, but from international law, will affect future decisions. But it's my hope that these new advances on international law will help judges to rethink their mindset, which is profoundly deep in their minds with the previous framework, a framework that believes that any of us has a problem that needs to be fixed, that we need to go through surgery, or that we need also a medical certificate saying that we are ill. Hopefully that will change. So we are right now in a very important moment for the judiciary and for the recognition of trans identities in Latin America. So hopefully this information and tools may be useful for what you are doing here. And I'm just happy to listen to questions after this or after my colleagues finish their presentations. Thank you so much.